Hello, everybody. It's Mike Sullivan here, author of Sullivan on Comp, and I want to welcome you to our talk with George Parisotto, who's the Administrative Director of Workers' Comp. If you're a subscriber, then you know that every month we do a half-hour webinar, which updates you on what happened last month, and then every quarter we do an hour and a half on some topic of interest. You know, like we did medical marijuana, we did the Rice case, we did a bunch of stuff over the years. And so if you're a subscriber, you already know this, and you probably already listened to more than one of these talks. But this one I think is special. I think this one is actually put out into the world. It's not just for workers' compensation, not just for Sullivan on Comp subscribers. And that's because we're interviewing the administrative director today. George Parisotto is here. Say hi, George.
Hi, everybody.
Hi. And I'm going to go to the next slide and show everyone what we look like. But so if you're listening in, you may not even be a subscriber. You may just want to be listening to try and understand George and what his job is and how it works in real life for him. Which is I'm really interested to find out about it actually, because I've always known only about it in a theoretical sense. Before we get too far into it, I was told to let you know that you can print a version of this deck, this slideshow, out and follow along if you want to. On the control box on your right, if you're tuning in, there's a section that lets you print it all out and you can just go along with us on the slides. Otherwise, we'll just be clicking through the slides as we speak. And so without further ado, let me introduce us. So on the left, we have a picture of me, Mike Sullivan, which is a lie because I don't have any hair anymore. I think it's time for a new picture. It's also a lie because I rarely wear a suit and my teeth are obviously photoshopped. I don't know actually who did that. If it wasn't me, I promise I didn't give that directive to any of my marketing staff. And then on the right, we actually have a realistic picture of George Parisotto, our current administrative director over up here in Oakland.
I will say the hair is a lot grayer now.
I don't know about that. I think it's looking about the same. I'm sure you're feeling more stress.
Oh, absolutely.
How long have you been in this job anyway?
Oh boy, I was acting administrative director for about a year or so, and then I was formally appointed by Governor Brown in October of 2017.
Wow.
So it's been about 2 years.
Okay. How long does your tenure last?
I serve at the pleasure of the governor, so I'm watching my door every day.
You don't have like a defined period, otherwise, I mean, I know he can fire you whenever he wants to, but
no, there's no defined period.
Really?
So right.
Wow, that's kind of tenuous, especially on a public servant's salary. That's gonna suck.
Well, it's makes every day an adventure.
I bet it does. Yeah. Wow. And Gavin's making moves all over the place. All right. Well, I wanted to talk about what we're going to talk about. So I envisioned a couple of different parts for this. First of all, I didn't really know. I knew there was an administrative director, and I know he did important things in the industry. But it wasn't until I started writing Sullivan on Comp that I got a clear idea as to what your actual job is and how you relate in the overall structure. What is the DWC, the DIR, the WCAB, and all these different things? These terms float around in people's minds in the industry, and we all have varying degrees of knowledge and perception about what they mean and how they relate to each other and what they do and the effect they have on the practice. But really, a lot of us don't know a lot about it, so I'm really excited to sort of expose it and then ask you about it. Because when I wrote Sullivan on Comp, I was like, oh, I was like, oh, every section, oh, I didn't know that. No, that makes sense, that kind of thing. So, and then, that's part one, is I wanted to talk to you about what your job is, just sort of in a free-flowing fashion. And then in part two, we took some slides from a prior deck that you'd had in the past that you presented at some conferences. And so a lot of what you do, I know, is deal with regulations and making regulations and various issues in the existing regulatory structure. And I think the part two will be, maybe you can expose to us a little what's going on with the things you're working on.
Sure.
And this list, this slide here says what the overview is and the things that you might be telling us about. So, but just to get started, so okay, let me see if I get this straight. Correct me when I'm wrong, okay? So in the beginning, there is the state of California.
Right.
Right. Okay. And there's the governor,
Mm-hmm.
and the governor and the Constitution say you can do administrative things in California. And then there's the DIR,
Department of Industrial Relations.
right, who goes directly to the governor, right?
Well, it goes through the Labor and Workforce Development Agency.
Oh.
So we have a Secretary of Labor, a new Secretary of Labor, Julie Sue, who is a dynamic force. Really, really great appointment by the governor. She is the Secretary of Labor. The Department of Industrial Relations is under the Labor Agency, and it's made up of various divisions, of which I work for the foremost, largest, and best, which is the Division of Workers' Compensation. Now, there are other divisions within DIR, the Labor Commissioner, so that's the Division of Labor Standards Enforcement. You'll also find Occupational Safety and Health, the Division of Occupational Safety Health, DOSH. I always refer to that.
Yeah.
I always refer to that. The Apprenticeship. Division of Apprenticeship Standards. And there's also other various commissions and underneath each of the divisions. For example, there's the Workers' Compensation Appeals Board. There's the Commission on Safety, Health, and Workers' Compensation. There's also the Office of the Director. Yeah, Cheeswick, exactly. Yeah. There's also the Office of the Director that has various units under that. The Office of the Director Legal Unit. And in the past, we saw the return.
But this is all under DIR now.
All under DIR.
Yeah.
So there's lots of moving parts in DIR that not too many people realize, and we're just essentially one division, although the largest division.
And the best, you said.
Oh, absolutely.
All right, I get it. All right, so you got the governor, and then the health and safety, and then underneath you that you've got the Department of Industrial Relations. Who's the director of that right now?
That's a good question. Right now, the position is vacant. We're waiting for the governor to appoint a director of the department. And so right now we're moving ahead. We're doing what we need to do. We report, up to the labor agency to let them know. And at some point, we will have a director in leadership of the department and move forward from there.
Okay. Sorry, I was switching slides. I was supposed to go to the slides for the last 90 seconds. So sorry about that, our studio audience. All right. So you report to nobody right now.
Well, we do have a reporting structure through the department. We have our chief deputy secretary, our chief deputy, who I report to, and of course we report up to the labor agency. So I don't think I'm not exactly running rogue at this point. Deciding that making policy on my own. We want to make sure that whatever we do is done in a measured, constructive way. We don't want to upset the system, too much at this point. I mean, if you think back, we've had a long period of stability in our system. We put in SB 863 back in 2013, and for the last six years, things have been fairly stable. Yeah. So we just want to make sure, and I think everybody out there knows that, it's a fine line between, running up costs or doing what have you. We want to make sure the stability remains.
So, how much autonomy do you have? I mean, what's your life like in relationship to the DIR? So I have up here the revolving fund, and what do you need approval to do?
Well, I usually make all the major regulations. For example, we have to, go up the food chain and make sure everybody realizes, what we're doing, how we're doing it, and how it affects the system. In terms of policy and decision, I certainly work with my staff, and I will say I have a great staff that I work with. We get together, we decide, well, how are things working? How are things not working? How can things be better? We put together proposals, and then we want to make sure, as I say, that everybody above us knows what we're doing, is aware of what we're doing, and the reasons why we're doing it.
Yeah, but do you do that because you just want to make sure your bosses are on board with it, or are you doing it because you're still sort of regs and statute require you to do it?
Well, there are certainly, of course, the authority that I have is given to me through the statutes. I can only do so much. I'll give you an example. The WCAB recently put out proposed regulations. They certainly operate, within their own sphere. But a lot of people called me up and said, "What the hell are you doing? Putting out these regulations, doing this or doing that. We don't like it. Change it." And it's like, well, I can't change that. I don't have the authority to change that. That belongs to the WCAB. So I operate actually within somewhat of a narrow area. If you look, you'll see the uninsured employers and subsequent injury funds. Generally that's handled under the office of the director. I usually did not have a lot of control over that.
No, that's not in your bailiwick.
No, it's not.
It's directly in DIR.
Right. We were given administrative control over those units. So, for example, I think the people that work there are DWC employees.
Oh, really?
But for the most part, that is handled kind of at arm's length from us.
So they made you just do all the work, but they're responsible for
pretty much. They take it out of my budget.
Well, that's really the question, right? Like, what is the revolving fund? I mean, how do you get funded for all the stuff that you do?
Well, years ago, we used to go and essentially request money from the legislature, from the general fund to operate DWC, but that changed. Oh boy, SB 749, way back when it became user funded. So our budget.
User funded means you go to all the employers and take away our money.
To put it in those terms, yeah, I guess you could say that. But they take our budget, and it's not just us. I mean, you look at the subsequent injury fund, the UEF, their fund, their costs, and then there's also some additional costs. I think DOSH is part of the assessment, and also there's a labor enforcement fund that's also part of that. And you take
What's DOSH?
The occupational safety and health.
OSHA.
I think OSHA. I think there's part of that money goes to them.
Okay.
There's about six or seven funds, I believe, that are in that assessment. But you take our budget, you essentially base it off everybody's premium. Complicated formula. I had to look at that multiple times before I even got a concept of how it worked. Something like AB5, but once they determine that, then employers pay into the fund, and then the fund goes straight to us. Or part of the money.
Oh, I see. So it's figured out ahead of time. And is it based just on history, or is it based on the stuff you say you want to do?
Really based on, I think, our last budget. I think I'd have to check. As I say, it is complicated, but they determine what our budget's going to be for the year, and that goes into the assessment. And I think everybody gets their letter about in November of what they need to pay.
What about hiring and firing? Do you have to get DIR approval for that?
Well, that's been a little complicated lately, I will say. We had authority to do that, but over the last few months, our hiring authority was. We have to answer to Cal HR. So now we're trying to move the process through that. We've had to undergo a lot of training in the last few months just to make sure our hiring processes were clean. We had to go back and look at all the hires we made.
Is that because the last administration kind of left under sort of a cloud?
Well, there was a report from the State Personnel Board that essentially said, you have to really look at your hiring practices, and you have to do some training, and we're doing that.
Wow.
So that
must be really hobbling too.
It's a little tough out there right now. We have a lot of people. We had about 1,000 employees. Very, very diligent workers. But trying to keep up with the workload has proven to be a challenge. But we've got all of our. I think we all have all of our ducks in a row at the division. We've got a great hiring staff. We've got. I think everything we need, and so hopefully we'll get our authority back fairly soon, and we'll move ahead and try to make sure our offices are all fully staffed. Employment issues, employee relations, that's it's a lot of what I do. Looking at various personnel issues that come along. I don't think many people realize that. It's always, you go out and it's like, why aren't you doing this regulation? Why aren't you doing this regulation? It's like, well, I have to make sure there's an office to put people in. I have to make sure facilities work, that the faucets have water coming out of them, and that people, that people at their workstations, have the tools they need to succeed. That's a big part of what I do.
Yeah, I'm not like anything like your scope, but I run an organization too. I know what you mean. It's kind of like if you facilitate all the people in your organization, well, then things work. So
right.
You end up doing that.
Mm-hmm.
You're
exactly.
not like actually doing stuff yourself.
No. Yeah. It's much different than sitting down and having to open a law book and making sure that this what's the interpretation of this statute, what's the interpretation of that statute. Well, there's always the administrative part of it.
Do you know how do you tell if you're doing a good job? What I mean to ask is are there expectations put on you by DIR or the governor's office, and then you either accomplish them or you don't, or is it more a matter of public perception on a day-by-day basis?
Well, we have our goals that we like to reach. We kind of aim high. Some, we don't really always get there. So we have our own internal goals that we like. I always went by that rule of thumb that if everybody on both sides hates me, well, then I'm doing a great job.
Yeah.
I know that that's the case in some instances. I think with the new administration, once they get their footing down, once we have a director in place, then I think we'll really have our more defined goals as to what we want to accomplish. Certainly when we get a legislative mandate, we have to work, hard to put that in place.
Yeah.
And sometimes it's tough to get resources to do that, but we show up every day and we try to be as diligent as we can.
Well, we were talking before about, as we were prepping about the story of SB 863 in 2012. I remember that August. And what had happened was Cheeswick, which, for people out there who don't know, you actually know what that, what does it stand for?
It's Commission on Health and Safety and Workers' Compensation.
Right. And that's under the DIR, right?
Correct.
Right. So you got some employers and you got some representative of employees.
Right. It's made up of labor management.
Yeah. So there was just very, very few people that knew about SB 863. And then just a couple of weeks before the end of the legislative session, here they come to all the senators and Jerry Brown says, you vote for this thing or I'm going to kill you. And they crammed it through and it passed. And it was really an amazing story. And I understood that the administrative director was involved in that. What that makes me wonder is how much of your time is spent sort of listening to what everyone out there on each side has to say, or working with particular parties in order to, hammer out compromises. How much of a compromiser, adjudicator, mediator are you, as opposed to a leader of, manifesting the ideas?
I try my best. I like to hear the ideas of the people that are out there. We want to hear from all sides. We want to hear what's important to employees. We want to hear what's important to labor. We want to hear what's important to the employer side. Once we get all that in, we try to synthesize it to try to determine what's the best policy that's out there. I personally haven't really tried to twist any arms at this point because, as I say, our system's been incredibly stable for the last few years.
Yeah.
There are probably things that we will want to tweak in the very, very near future, and I think we'll do that with some of our upcoming regulations. Again, what we want to do is eliminate friction in the system. So I think once we get our leadership in place in the department, then we'll move forward and we will talk to people and we will try to convince them of things that will work.
Yeah, there's the whole process. I guess it's, the situation with SB 863 was, hey, let's pass a new bunch of statutory things, right? And then the regulatory process is very open with a lot of contributions and periods of comment. And so what you're saying, I think, is that, hey, look, there's a whole lot of collaboration and hearing people out on the regulatory process. Right now, we're not making any major statutory moves.
Nothing major at this point.
Yeah. Well, everyone's wondering what Gavin Newsom's going to do with comp. I mean, he says so far he's not doing anything, but I know that some people on the other side would like to do things like kickback, rollbacks, and UR, MPNs, things like that. So it's going to be interesting to see if he makes any moves.
Well, we'll see what the proposals that are out there, and certainly the administration will come and talk to us, and we will tell them what we think works, what doesn't work, and what will move the system forward. What we really need to do, at least from our perspective, is try to eliminate as much friction as we can in the system. Friction pays. There's an incentive to have friction just because of a lot of the money that's being made. We want to be more efficient. We want to make sure injured workers get medical treatment and they get back to work as soon as they can. That's our important goal. And to the extent that people make proposals to do that, we'll certainly back them.
Yeah, I think you're right. There's a lot of money to be made. I mean, I'm a defense attorney, so
you're rolling in them. I mean,
not these days. No, because we cleaned up so much stuff that
Right.
there's less claims, there's less litigation. I mean, if you're good at your job, you're always going to be okay, and certainly our firm's fine. But there's a lot less people with a lot less vested interests than there was a decade ago. That's for sure. I was wondering a little more about your relationship with the WCAB, and I wanted to explain to our listening viewers a little bit about this. A lot of people don't know it, It's kind of crazy, but in the DWC, in the Division of Workers' Comp, there's really two branches, right? There's administrative, which you're in charge of, and then there's the judicial, which is the judges.
Right.
And there really is two separate parts, and that's it. That's the DWC, as far as I can tell. And what I want to just put out there is the basics. You can tell me if I'm wrong, but excuse me, the governor will appoint 7 commissioners. And those commissioners are like the Supreme Court of workers' comp in a way. They're the ones that decide, well, they can always be appealed to the Court of Appeal or the Supreme Court. So I probably shouldn't say that, but they are the 7 gods and goddesses of, the law of workers' comp. So whatever a judge at a local office says is subject to their approval, is it either in terms of fact or of law. And so if you go to trial and you lose, and you don't like it, you file a petition for reconsideration. It goes up to the 7 commissioners,
Right.
and that is the Workers' Comp Appeals Board.
Correct.
Right. And then they're in San Francisco, and they have this staff of lawyers that are looking at all these petitions for reconsiderations. And so, every judge stands in the shoes of, in fact, one time I had a case, I was being a defense attorney, right? I was really proud of the case because what happened was it was the worst case in the world. Okay. The applicant was the worst person that's ever been invented by the Almighty. And that was demonstrated in extremis in the trial process. Okay, but the judge was a pot-smoking liberal hippie, and he gave it to the applicant. So I did recon, and then I sent it up to the WCAB. And what impressed me is that not only did they overrule the judge, but they entered a finding of take nothing on the judge's behalf. And what that demonstrated to me real clearly was that judges are just a stand-in for the commissioners. I mean, they will trust the judge's discretion, and they're obliged to do that. But that's it, right? So they really are. But the thing about it is it's kind of like in the federal government, you got the Supreme Court, right? And they decide all the judicial things, and they're the holders of the law. And then you have the executive and legislative branches, right? So these 7 people are calling the shots. They get to say what the law is in workers' comp. They do en banc decisions.
Interpret our regulations.
Yes, they interpret, all law, statutory, regulatory, everything. All law is in their hands. They get to say what that is. But they have administrative needs, right?
Well, that's true.
Yeah. So I'm wondering, what is your relationship like with these people? I mean, do you talk to them? Do you guys hang out and go to ball games, or do you not get along? Or
you know what, they are all great people. I must say, I think it's great. I think it's great. I enjoy being with them. Incredibly smart. We kind of keep at arm's length, honestly. The judges, the workers' compensation administrative law judges in our district offices, they are employees of DWC. And we make sure that they have the tools to succeed. We take care of the offices. The district offices belong to DWC, all the facilities, the DWC. We make sure that they have staff to do their jobs. Those are DWC employees. Where we take a step back is the policies and procedures they follow, and also the law they need to follow. Judges, and our judges do a great job. They follow the law as provided by the WCAB. The regulations that they do follow in terms of procedure, again, those are promulgated by the WCAB and not us.
Right. So that's administrative stuff.
Right.
But their administrative stuff, you leave them alone on.
Well, when it comes to looking at a case, when it comes to making decisions, that's hands off for us.
Like if they hire a secretary.
Well, that's something we would take care of.
Oh, okay.
So that would go through our DWC hiring process.
When the secretary says I was harassed, I'm going to sue you. You have to deal with that.
Right. That's what we have to deal with. And again, facilities. The offices themselves.
You rent the facility.
They're either in state buildings or in their leased facilities, and we want to make sure that they have security they need. We want to make sure that they have, again, the computer systems they need.
Okay.
They look at EAMS. That belongs to us. So, we kind of take care of everything around them. while the decision making and the procedures they follow are controlled by the WCAB. We work with the WC in forms. A lot of those forms we sort of share. We put them together. Some of them we put out, but we have to work with them to make sure that they
So you rent the buildings, you buy the paper baskets, you hire the people, you handle the personnel issues. You are basically running support for these judges.
I would say, I think that's one way to describe it. Yeah. Again, we give them complete freedom in how they decide their cases.
But there was also, well, yeah, that's good, right? Because you don't want to mess with it's sort of sacred.
Well, it is.
The finding of what the law is and what the law isn't is sacred.
Right. We don't tell them, we don't tell them what to do. We don't tell them, that you have to interpret our regulations this way. That's entirely up to them.
Okay. I think I understand. There was this position of court administrator that they made years ago, and then it removed it.
Right.
And as I understand it now, there's like a chief judge or
right
chief of all the. Now it's Paige Levy right now.
Yeah, Paige Levy, who fantastic.
No, I used to appear in front of her.
Oh, she's great.
Yeah, she was hard on me.
She's great. I honestly don't know what I would do if she wasn't there.
Right. Okay.
But she works with our presiding judges. She works with our judges. Again, helping them on the administrative side, telling them, these are our internal policies, how we work with,
right. So for a long time, there's like it's the local rules, right? Mm-hmm. So we have the DWC policy and procedure manual. Does she do that, or do you?
That's worked through the WCAB.
Okay. But she'll probably be on point on that.
Well, she certainly gets involved with that, and she certainly talks with the WCAB.
Because the steps, I used to go to different boards. The steps and issues would be different. CNRs would be different. Every forms would be different.
Yeah,
procedures would be different. Getting off calendar, on calendar, picking judge, preemptory challenge. But then over the years, they've tightened that up so they made it uniform.
Yes. Paige has made some great progress in making sure that the rules in one district office are the same in the next.
Yeah, but she's not yours. She's theirs.
No, she's a DWC employee and a part of our management team. Right. So she's separate from the WCAB.
So there's not a lot of friction. You guys really work together. Do you guys ever get in fights about who gets to do what? Does she like say, I want to buy these chairs, and you say, no, we're buying these chairs?
No, we usually both shake our heads and just say, how much are these chairs costing?
All right, well, fair enough. And then I wrote down here your statutory duties. I saw that you actually have duties that you have to do according to the statutes, and we talked about a lot of them already. Mm-hmm. I had here March 1st annual report to governor, and that was insolvent on comp, but I found out that was wrong, and I changed it.
That's right. That was part of, I think, Labor Code 111, and that was amended a few years back to get rid of that annual report. We do reports.
Yeah.
We have an IMR annual report that we issue, and then we also have our audit unit. They issue an annual report. The Commission Cheesewich issues a report that contains a lot of information about what the division does. Okay. So there is information out there about what we do on an annual basis. But that report that went by the wayside.
Because of this presentation, I found out that we had a mistake in Sullivan and Comp, and I had to go fix it. So now I'm embarrassed. Well, we talked about some of these things. You're keeping the public informed as we speak. Right? I see you at the conferences.
Yeah, we try to get it out there.
You get your website.
Try to get out there every so often. We have our website. We want to make sure that that's updated. We want to make sure the information's out there that's easily accessible.
Is that different than the DWC website?
The DWC website?
Is there a difference between?
No, we have a DWC website.
I mean, the WCAB. Does that have
yes, they have their own website. It's all under the Department of Industrial Relations. There's a central website for DIR, and from there you can go to each of the divisions.
Right.
And you can go to our page, which I think is probably the best one out there.
It's the best page.
I'm not biased in that decision and that opinion, but anyhow. But again, we want to make sure that the information there can be easily reached by people who might have questions. I think we have a lot of work to do in terms of outreach. We're always, and I guess as a state agency, maybe I could say something like all state agencies, we're a little behind in kind of moving ahead on the cutting edge of technology and outreach. And I think that's one thing that we would like to do in the next year is get more of a presence out there, whether it's videos on our website, utilizing YouTube, or other things like that. We certainly go out and we give speeches, we talk, we try to reach all injured workers throughout the state. We give our INA officers, give presentations in Spanish and other languages to injured workers. But I certainly think we could always do a better job. But getting out there is important.
So there's one DIR website, and then as you go down, then there's a DWC website, and then there's a administrative director website, and then there's a WCAB website.
Well, there's no administrative director website.
Okay.
So just the DWC website.
Because that would be dumb.
Oh,
You're all supposed to be one thing.
Yeah, that's true.
The DWC website.
Yeah.
And you get all the forms.
Right. You can get all the forms there. You can find links to regulations we've had approved, the ones that we have pending. All of our units have their own links and various processes. It's really quite useful.
It is actually. We and Sullivan & Comp, we link to the DWC website all over the place.
That's correct.
Like if there's a form that needs, we say, oh, go here,
and
we link it on our electronic version. Because we thought about like having our own set of forms, but they're always changing and things are added. And it's like, I just link it to you guys because you guys are the ones responsible for publishing to the world correctly.
Yeah, we try our best. And forms is form is a 4-letter word to me. I think we could do a much better job on our forms. Making them more uniform, making them more user friendly, and that's something I'd really want to make sure that we do in the upcoming years.
You think so? I think they're pretty good.
They are pretty good. They are pretty good. But I guess if you go from form to form, they're just they're slightly different. And I want to make sure that everything consistency is important, and I think we could have better consistency.
Sometimes they're right in the regs, and sometimes there's things you're directed to create.
Right. Yeah.
So you have discretion to change some of the forms.
Yeah, there's going to be probably some wholesale changes coming up. I think the WCAB, as part of their rules, renumbered practically every regulation they have, which means I have to go back and change all those forms to make sure that they're accurate.
Well, the rules and regulations, I was surprised to see this when I was writing Sullivan & Comp, that there's WCAB regulations and there's administrative director regulations. And they actually have the same exact force and effect of law as far as I can tell.
Right.
And you get your book from Lexis, your blue book that has all the regs, and it just tells you what the regs are. So it doesn't make any difference to the practitioner as to who originated them. But in your mind, which ones you're working on. They know, which ones they're working on.
Yeah, they're the ones that I've torn out of the book and thrown away. There's the ones I keep. There's the ones I mark and yell. Yeah, I know how that breaks down.
But that's where you live, right? You live in regulations.
That's that's our primary goal is, our primary role is to make sure that we look at the statutes that have been signed into law and have regulations that implement them. We want to, make sure that we're not duplicating anything. We want to make sure that, that we have everything covered and that everybody really kind of gets their shot. Due process is very important to us, and some of the statutes in place are kind of head scratchers. As well, we have rights and remedies, but what happens if somebody gets something wrong? I think that's kind of the biggest challenge we face. And it's funny when you look at that book; it's a huge book. And I think probably 1,000 pages had been added to it over the last 10 years or so.
You could choke a small rhinoceros.
Right. It is kind of ridiculous. And I think at some point, because, when you
past. Have you seen Oregon? It's like 3 pages long.
Yeah.
A lot of the other states are just teeny weeny.
I know, you're hurt, go to a doctor, get the treatment you need, here's some money. It's kind of frustrating to see, but I think that's just kind of part of, I won't say part of the problem that we've had over the past few years, but when you get reform after reform and you layer regulation on top of regulation, it's hard to keep track of them, and it's also hard to keep them together. I always kind of refer to it as something of an elaborate spider web, and it's really hard. You move one part of it, and then it has this ripple effect. And I think at some point it'd be great to go back and really just get rid of those regulations that we don't need.
The problem though is that California is just so much money in comp in California, and it's such a opportunistic and liberalized environment. So, what I mean to say is there's always someone looking to game the system and make money off of it, so start doing funny stuff. Well, look at IMR, you are, for example, right? You can't just go into a judge and say, is this reasonable or not? Because there's so much opportunism in the medical side that you need that. Well, the defense at least thought you needed IMR, UR, but they're massive bureaucratic realities, but they just don't need to exist in other cultures.
Right. Gaming? I'm shocked.
Well, yeah, we're gonna see in some of the other slides just how bad it is. I saw something, I'm like, oh my god. But I guess I shouldn't complain because the defense attorney, I mean, right now I'm wearing my neutral Sullivan and Compat, but as the guy who runs a defense firm, you know, you don't want to see gaming, but on the other hand, it's how we make our living is stopping it.
Well, we want to make sure that if there are disputes in the system, there are ways to resolve them, and we
Yeah.
want to make sure that it's done efficiently and correctly.
I have this, let's see, this thing where petitions for change of treating physicians. You know, my first job when I was in law school was at Hastings. It was Susan Hamilton was working at the Department of Industrial Relations, and I was looking at petitions to change treating physicians. But my understanding is,
you know, Susan, fantastic. I learned so much from her.
Yeah, she was cool.
She
was my boss.
She and Richard Newman, you know, two of my idols.
Oh yeah. He was one of my competitors who wrote the St. Clair book.
Yeah, right.
Yeah, so I don't like him.
Well,
no, he's a great guy. What can I say? But anyway, yeah, I don't think you probably see too many petitions for change of treating physicians in the present environment.
Not many at this time. We put in a regulation that does not allow for a change of treating physician petition in the medical provider network realm. And since most treatment now, you know, some people say it's up to, you know, 85% of treatments are within MPNs, and we don't see them. There were definitely a lot more in the past. You know, we do have administrative director decisions that we do.
Right.
You know, there is the change of treating physician petition, reconsideration of ratings, summary rating determinations. You know, those come to the AD and we issue decisions there. The vouchers, that's the request for dispute resolution.
Well, let's go to the next slide on that note, because I have here all of your units.
Right.
So you have, when I was looking into this, when I was writing Sullivan and Comp this chapter years ago, I realized that there's formal units, you know, that are enacted by regulation. And then there's just some things that you guys do.
Yeah, exactly.
Yeah. So, but I sorted it out into this list. I don't know if you think it's accurate or not. But.
That's actually quite accurate. You know, our audit unit that's been around for a long time. You know, mandated by Labor Code 129, 129.5.
No, you know, I consult with a lot of my clients on audits, and I can tell you that they're effective because my clients, they don't really live in fear of 5814 petitions. You know, they don't really live in fear like they used to back when it's a penalty on the whole species of benefit. Now they want to make sure that if the audit unit looks at something they're doing, that there's no color of it being done wrong, because it can really hurt, and even their license is an issue. And so I can tell you from just experiences, a defense guy that consults on a lot of audits, they're effectively motivating the carriers and the TPAs, I think.
No, audit units, they do a fantastic job, and we've had a history of great audit unit managers throughout the years, and they just do fantastic work. I think we want to look at their regulations that have been in place for a long time and try to update that.
But OSIP is through DIR, right?
Yes, that's exactly.
Office
that's part
of Self-Insurance
plan, right? Part of the director's office.
Okay, so the audit unit will look at carriers, and then if it's a self-insured entity, it's looked at by the DIR audit.
We'll look at that. We'll look at those also.
Oh, okay, well, it's a double whammy.
It is at times. It's something very interesting.
I see. So you just go through all the TPAs and carriers and audit, regardless of, you know, whether or not they're self-insured. But then self-insured, the OSIP, they step in. They also have their special things.
They also do their own thing.
Yeah.
That's right.
Boy, why would you ever want to be self-insured in this state? Well, no one is. Everyone just gets a high deductible and is insured, right? $1 million deductible. So it's like all the benefits of being self-insured without actually being self-insured. See that all the time. Yeah. Maybe that needs looking at too. I don't know. And then you got your raters.
Right, disability evaluation unit.
You got EDEX and EAMS. We're talking about EAMS at the end.
Yeah, we'll talk about EAMS at the end.
Yeah.
You know, our INA unit, they do a great job at the district offices helping injured workers. The medical unit, a lot of that we took from the old Industrial Medical Council back in the 2000s.
What is the medical unit? Is there a guy in charge of that?
Well, technically it's headed by our executive medical director,
right?
Raymond Meister.
Okay.
And then we have a manager of the medical unit who tries to keep it all together. And then there's different units.
What do they do there?
Well, they administer our QME program. So panel requests, you know, they issue panel requests. We have our discipline unit within the medical unit. And then there's also the MPN, you know, MPN staff. Then we have a UR investigation part or section of the
It's like
medical
an
unit.
independent audit unit, sort of. Right?
Yeah, it is. They operate apart from the audit unit, but they look at utilization review
Yeah,
organizations.
that was a special enacted law. When was that? I can't remember.
Boy, well,
Was
that was
part of SB 99?
899, right?
Yeah, okay.
Right. When UR was brought in, so
Right.
we created a separate investigation structure for that.
Okay.
So the medical units really kind
And
of
you pick
far-reaching.
QMEs too. You give the tests. And
Correct. That's also
run the whole
part.
QME system. That's a lot. How many people work in that unit?
Not as many as I would like.
Oh.
It's really funny. People, I think, have the impression that we are much larger than what we actually are.
How many people work for you, for the administrative directors?
Well, as I say, I think I have roughly, ballpark 1,000 employees, but most of those are in the district offices. A number in headquarters doesn't really readily come to mind. But again, I don't think it's as big
Can't
as.
be more than a couple hundred.
No, it's not as big as people would think.
Shoot, man, my law firm's bigger than that.
Yeah, surprisingly.
Yeah, you need more resources.
That's what I always say.
They're trying to do stuff. Okay.
And
then the research unit. I mean,
research unit, we're somewhat rebuilding. A few years ago, DWC had its own dedicated research unit, and then it was determined that it actually should be put under the director's office. So it was kind of taken away from us. But recently we've been making moves to bring it back because there's a lot of data that we collect, and I think that's I think one part of this that isn't really that's not mentioned is our workers' compensation information system. Claims administrators have to report claim data to us, both information about how the injury occurred, payments, indemnity payments that are made, and also our medical billing data.
Oh.
And so through the IT unit, we collect a tremendous amount of information. And I think you'll see as we go on, we're going to collect more through the doctor's first report. And then there's also UR data that we need to collect. And so given all of that, I think it was really incumbent upon us to have a dedicated research unit again within the DWC. One, so that we can look at our own data and try to determine trends to make sound policy decisions.
Are you doing that?
We are. It is being done.
Okay.
Can
you just do it, or you have the authority by?
We could do it if we had everything in place to do it, where I could say, okay, well, how many spine surgeries are occurring right now? I could find, my research unit can do that. What are the trends in that? But right now we really don't have that in place. And so we depend upon outside researchers, for example, the RAND Corporation, to do research. And so our research unit will do that. We'll also, have a dedicated staff to look at fee schedules. We have a lot of fee schedules in place, and more are coming. So, when Medicare puts out something, we want.
I was thinking legal reseissearch, but this is like data.
This is data. Yeah, right. You're right. We have one thing that's not mentioned here is our legal unit.
Why isn't that on there? Whose fault is that? Oh wait, that's my fault.
we have great attorneys working for us.
How many of the attorneys do you have in your legal?
I think about 10, 13.
What do they do?
One, they provide advice to all of our various units, and then they're the ones who are in charge of putting all of our regulations together, making administrative decisions, in the cases that come to us, and then also, answering
approval of contracts.
Yeah, and then of course when I'm running down the hall screaming, they want to make sure that I'm somewhat protected.
Yeah, who is responsible for your personal sanity? Is it the legal unit?
Well, it's certainly not my family. No. I would say my legal unit, my chief counsel is tremendous.
Who is that?
Yvonne Hoskariag, and I could say her name correctly.
That is impressive.
She's she's great. And she has my back.
Yeah, so your right hand there.
Mm-hmm.
That's good. That's interesting. I have here that the research unit also administered carve-outs, application and regulation of carve-outs.
Right.
Carve-out.
Well, right. We are, we're trying to get our carve-out staff together. Carve-outs, from our perspective, is I won't say it's mechanical, but when groups want to form a carve out, and we're seeing now a lot of them regarding public safety, officers, firefighters or police, when they wanted to negotiate a carve out with the city, they would file an application with us, an application to begin negotiations, to be allowed to negotiate. And so we make sure that everything's correct, primarily that the union who's going to be involved in the carve out actually represents the workers. That's generally not a hurdle.
Is that in the research unit? That's what those people are?
Well, not now, but I think at some point we want to make sure that is part of it.
Floating around the administrative director's office.
Yeah, we've been trying in the last few months to look at our internal structure and make sure that it makes sense. We really haven't changed our structure in years, even though more and more obligations have been imposed on us. Like for example, the medical unit. DWC, I think before the year 2000, really was just there to regulate claims administrators. But now we've been given more responsibility in terms of medical treatment, and medical treatment guidelines. The carve-out program came in. All of this has come in.
You guys are always updating the medical treatment guidelines, like always.
Oh, we're doing a great job with that. Yeah, we're doing a great job with that.
In a second.
That's been one of our primary focuses over the last few years.
All right. Well, let's get into it. I'm going to stop cross-examining you and let you expose the world to, some of the stuff that you're doing in terms of the regulatory changes and the specific changes you're trying to make. These are so I'm going to put this here. So I'll let you control it. Okay.
All right.
So press that arrow down and it goes to the next one. But we're going to talk about the new legislation. We left off on purpose AB5 because it doesn't really pertain to this discussion. But you did want to talk about SB 537. What's
right? SB 537 was signed by the governor, and so I think this is the one which really is probably going to affect us more. Of course, as I say, we'll take AB5 and put it to the side. That's a real piece of
a whole other presentation.
That's going to be interesting. I'll be very curious to see how that affects DWC. I think we're going to see quite an increase of litigation in our courts, and then also with the UEBTF, the uninsured employers. If some employers really don't get on it and understand that they have to get workers' compensation coverage,
right.
we could see that fund really being affected. But I'll put that aside. SB 537. This was signed by the governor, and I think will be interesting to see how this works out. The one thing that stands out, of course, is the requirement that we publish data on utilization review and physicians who request treatment. So any physician who treats more than 10 patients,
why do they want you to do that?
Well, for years now, there's always been the belief, and to the extent it's somewhat true, that's a small number of physicians who are driving, for example, independent medical review, IMR, the top 10% of physicians account for 25% of all IMR. And when you go down to utilization review, it's the same. It's only a small number of physicians who are pushing a large number of treatment requests that end up getting denied in utilization review. And so for years we've been asked, can you identify these bad actors and putting them up on the website? Now that's somewhat problematic for us to do without statutory authority. And so we've been, sitting back saying, what? Well, we're going to actually just need something express, and this is what that does. And so we're going to have to really take a hard look at our data and the data sources. SB 1160 a few years ago gave us the authority to go out and collect utilization review data. So we're going to have to work to see what are the meaningful data fields. What should we be looking for?
Are you going to kill the doctors?
Well, to the extent it is reasonable, we'll list the names.
Yeah.
We'll list names, and then
names.
Yeah, I don't know if you can associate bad behavior with activity, but the data will say what it says. But we'll take a real good look at it, because I don't want to put up anything that's incomplete or would mischaracterize anything. But
of course, applicants' attorneys are going to say these are the ones that have the guts to individualize necessary treatment.
I'm sure that, as I say, the number.
Therefore, should we restrict or repeal or allow for the appeal at the WCAB level if you are?
Well, the numbers will say what they say, and people will spin it however they want to spin it. But it will be very interesting to see how that's going to come out. The bill also defines normal business day. That's been a bone of contention. The WCAB issued a decision on that not too long ago. Taking Saturday out as a working day or a business day, or I'm showing up at the office and not working day, however they want to call it.
Right.
But now that's being defined by statute. And then we also have some requirements regarding MPNs. provision prohibits anyone other than the requesting provider, from altering treatment requests. So I think those will be helpful in sort of cleaning up some problems that we've heard were occurring in MPNs. So we're looking forward to getting to work on this and putting it into effect.
Okay. Lien stays.
Yeah, anti-fraud. This has been a real big part of what we've been doing the last few years.
Everybody's in jail, man. It's like all those bad actors are all.
And Felicity Huffman, she's a good actor though.
Yeah, that's true.
That's sad. I like her work. Yeah. A couple of years ago, the issue of provider fraud came forefront, and legislation was put into place to essentially let us get out of this system. And they've given us some tools to do that. Lien stays. So if a physician or provider has been charged or indicted with fraud, Medicare, Medi-Cal fraud, all of their liens in the system in EAMS are identified, and we put a stay on them.
Yeah.
Until those charges are disposed of in one way or another.
Though, because we can't. Clients just want to close the file.
Understandable, but we have to make sure.
Can you even approve a settlement?
No. Once they're stayed, they're stayed.
Yeah, but we could just agree informally and then write them a letter.
I guess you could do that.
Well, that's how most liens are settled out of court anyway, without an order.
So we've stayed these liens, and as this shows, we've had over 650,000 liens designated as 4615, and we designate them that way because if the provider feels like we've made a mistake or there's some error in the entity that's had their lien stayed, they could certainly go before a judge and make that argument and have the stay removed.
180 criminally charged individuals. Where would you go to find a list of that?
It should be on our website.
It's right there.
Yeah.
Everyone who's criminally charged.
Yeah, I don't think it's not on our website. I think you have to go to the DIR website and look for the link for that, and you'll see those who have been criminally charged.
Wow. Well, just being charged is enough.
Just to have lien stays.
Ooh,
yes.
One might argue that there's a due process issue there.
Well, as I say, they could always go before a judge and argue that there's a mistake. The arguments have been made, and I think for the most part, we and the anti-fraud unit has been successful in combating that.
Yeah, I think so. It's an amazing thing, though. An amazing thing. I mean, just looking at these numbers, those of us who have lived in the system the last 15 years knew what was happening, But man, look at how the chickens come home to roost.
No, it's had quite an effect, and then I think there's one number I'll come to, which really kind of brings the point home.
Yeah. Okay.
Provider suspension. So once someone has crossed that line, has been convicted of a felony or misdemeanor, involving fraud, Medi-Cal, or had their license suspended. At that point, we start the suspension process, and as this shows, we've had over 400 physicians, practitioners, or providers suspended, and that's a process where we send out a notice of suspension. If they want to appeal it, they can. They could ask for a hearing before our special adjudication unit, which is part of the where we have judges who hear these cases.
It's like a WCAB judge who will hear this.
Yes, exactly. Yeah, a workers' compensation administrative law judge would hear this.
Okay.
And issue a decision, and we'd issue an order of suspension if they found that essentially that the person, the person was convicted of.
How long do they get suspended for?
They're gone. It's indefinite.
Forever.
Yeah. So can't come back into the system.
That's terminated. Is there a redemption process?
Not at this point. So if you've been suspended, you are suspended. So you can't be involved in the workers' compensation system as a provider. You are a physician, one of our anonymous IMR reviewers. You just can't do that. And as I say, but there is a process. So again, if someone believes that we are suspending them inappropriately, they can appeal and then go to the civil courts. That's not a process where a decision of a judge goes to the WCAB. It goes up to the civil courts.
It's appealed directly to the civil courts.
Right, because the suspension provision is as I learned this, it's in Division 1. It's not in Division 4 of the Labor Code.
I didn't know. Maybe I did know that, but I didn't today.
A lien consolidation proceeding. This kind of follows from the suspension proceeding. So if someone has been suspended, then all of their liens are identified and are subject to just being removed from the system by operation of law. And the burden is on the provider to come in and show that the criminal activity was not connected to that specific lien. Right. And so we've had, as I say, 19 of these processes move along since the statute's been initiated. You know, we also get rid of liens that have been the part of plea bargains. So if someone essentially takes a plea on their criminal case, and they can reach an agreement that their liens will be dismissed, and then we can go in and do that too.
Where would we find a list of those lien consolidation proceedings, or which lien claimants are subject to it?
I will have to check. You know, those providers who have been indicted, charged, and then also our suspended providers are there. Right off the top of my head, I have to say, I apologize for this. I'm not sure how our lien consolidation proceedings are listed on our website.
I apologize,
but I will
too.
take a look on
that. I have a fraud unit.
Yeah, there is an anti-fraud unit. It's in the director's office. You know, they're the ones in the front lines.
Look, by asking just one question, I made us both look stupid.
Thank you. I will say it doesn't take much to make me look stupid. But it's just a question.
Modesty becomes you. I won't even try.
And then we have a lien declaration. You know, EAMS in the past few years has always been a sieve. You know, people could file essentially a lien, have a receptionist sign. Who knows who provided the service? Who knows what service provided? But there was a lien. The lien declaration is an upfront filter to make sure that a lien that is filed is a valid lien. That essentially states that the person who's filing it is the person who's provided the service and is the owner of the lien. And I think this has had a great effect in reducing the number of liens. And the last line there you'll see is liens have been reduced from 30,000 filings per month to 5,000. That's had a tremendous effect on the system, and I think that's reflective of all of our anti-fraud efforts, as we've really, really brought down the number of liens.
Look at this, 300,000 liens dismissed for failure to file this declaration. They probably just don't bother, because how much of it do you think is driven by the lien filing fee?
I don't know. The lien filing fee, it's been, you know, it's there, $150, and that's, you know, I have to say that's one thing that kills me. Is, you know, when you had 30,000 liens per month with $150 filing fee, my budget was doing really well. You know, now we're down to 5,000, and I'm out on the street corner with a tin cup,
like,
you know, begging
more
people to give me money.
Please.
Yeah,
more lien claimants.
Yeah, it's a bittersweet pill, but it's something I think our system desperately needed. You know, we had to go in there and just clean out those liens, and this has had a great effect.
Yeah, see, we of course in my firm, we have 5 or 6 hearing reps that do nothing but liens. We've had to find other things for them to do.
That's good.
Because it's just over. The lien party is over. I really thought that the filing fee would be, along with, there's just like 10 different blows to the head, and SB 899
right.
and SB 63, the lien claims was wham, 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 wham. I had this picture in my mind of a boxer getting beaten to a pulp, all the different changes, you know. But the $150 was a killer, because you just didn't get it back. Unless you prove that, you know, a whole bunch of stuff, and you could just file a lien for anything.
Absolutely.
And you could extort the defense into paying, but that party just ended, and they fought it, but they lost. So, but of course, this filing, this declaration thing is also a big deal. I mean, there's a lot of like corporations within owned by this person or that person. There's just a lot of BS.
Liens have been assigned, sold. You know, people buy books of business, go and file liens years after the service has been provided. It was a mess.
It really was.
And so I think having this upfront filter, again, the lien declaration, has really been important to us.
There's lien claimants who will say, hey, this isn't fair, because if your lien is so small, you know, you can't pursue it effectively without some kind of a fee. But you know, I mean, you have to pay a fee in civil court to sue somebody.
Well, right. I don't think the amount is unreasonable.
You can get it back, but the time, and if it's not worth the time and effort, it doesn't mean they automatically give it to everyone else and expect it for free.
Right. And also, I think, you know, we need to make sure that liens that should be an independent bill review get over there.
Yeah.
I'll get to a statistic about independent bill review, a very underutilized program.
As it should be.
As it should be.
Yeah.
As it should be. Yeah. Medical treatment utilization schedule. This has been our big push, as I had mentioned before. We want to make sure that our injured workers get the best available evidence-based medicine. Our medical treatment utilization schedule is comprised of our treatment guidelines, and we've just recently updated them. We're using the most updated versions from the American College of Occupational and Environmental Medicine, ACOEM.
Yeah, just to make sure that for all levels of education out there in the world, you know, in SB 899, one big change was they said that utilization review did define what was reasonable care and what wasn't. So if you go to UR and it says it's not reasonable, then it just isn't, absent an appeal by IMR. So this utilization review became vital because it says whether or not you get the medical care, and that's it. And what's the basis? The MTUS is the schedule that is the basis for UR.
Right. It's our treatment guidelines, and it also tells you what to do if a condition's not covered by our treatment guidelines, or if you feel like for this individual you need to go outside of the treatment guidelines.
And it's rooted in ACOEM, which is an empirical exposition of care relative to conditions of pathology. And then, of course, there's other things too that contribute. You guys are constantly updating the MTUS to cover all possible situations in regards to types of proposed medical care.
That's right. December of 2017, we essentially took all of our treatment guidelines and put them aside. We actually had some of our own, which I thought were brilliant. Our chronic pain guideline, we had an opioid guideline. But as you'd mentioned, we adopted ACOEM guidelines in 2004, and we never really updated them up until 2017 when we brought in all of these guidelines. Certainly if anybody's really interested, go to our website, take a look at what we're doing with this. SB 1160 gave us the opportunity to update our guidelines on a more expedient basis, as opposed to going through the regular rulemaking process, which, in some instances can take up to a year. Now we can do it rather quickly. ACOEM comes up with an update. We take that, we schedule a public hearing in 30 days. We get comments, and then after that, we can adopt the guideline and put it into place rather quickly. So it's a matter of possibly 2 months or so.
You guys are doing this constantly. I see this almost like every day.
Well, in October, we brought in a traumatic brain injury chapter last April, post-traumatic stress disorder, and then some other chapters, spine, ankle, foot. In August, we had a low back disorder guideline. I think we're ready to adopt the hip and groin guideline. We just had a public hearing on it not too long ago, and then we're going to be adopting a depression guideline fairly soon. I think ACOEM finished that. So yeah, it's important to make sure that the best evidence-based medicine is out there, and we're trying to keep up as best we can, and I think that's working really well. We just introduced an online training program on how to use the MTUS, and I hope people go out there and take a look at it and use it. Because
why would everybody do that? Isn't it just the UR people?
Well, it's everybody. If a treating physician makes it, puts in a request for authorization, and the treatment is in accordance with the guidelines, it should be approved. There should never be a denial or a modification of a treatment request if the underlying request is substantiated, the documentation's there, and there's a citation to the guidelines, and this is how it works. There should never be a denial. That's why it's important for us to make sure that the frontline physicians are familiar with the MTUS and know the MTUS, because we issue 15,000 IMR decisions per month, and in many instances it could be that the treatment is reasonable, but there just hasn't been the dots connected, to show that conservative treatment was tried and failed before you got to this. And the guidelines really explain that, and so it's important that our treating physicians use that. We're now offering our guidelines, access to the guidelines free to physicians. I hope they're taking advantage of it. That really should have an effect on our system. I'll turn to our formulary. We were tasked several years ago to have a formulary in workers' compensation that was never tried before in our state.
What is a drug formulary?
Well, it's really a utilization review tool. We use our treatment guidelines and the medication that's recommended in the guidelines. We pick those that are most used in workers' compensation, those that have safe profiles, and we've created a list. Our MTUS drug list, again, you can take a look at this on our website. It's an Excel spreadsheet. Our staff did a tremendous job of putting that together. And it says what medications you can prescribe without having to go through prospective utilization review. So if a physician feels like an injured worker needs a certain medication right then and there, they can write the script, but the injured worker can take it and get it filled without having that time frame or having to wait for prospective UR.
So it's a list of conditions, pathologies, and a corresponding list of medications that can be authorized without going through the UR.
Right. So it's a list of medications, and then we have links to the guidelines. So someone can go see where in the guideline this medication is recommended or not recommended.
Where would someone find this spreadsheet?
On our website. It's right there. Take a look for the formulary. And you can really take a look at the Excel spreadsheet. We are working on it quite a bit.
Why is this helpful? I mean, why not just have people request drugs and it should go through right through the UR process? Why have a separate drug formulary?
Well, again, it's a tool. We want to eliminate prospective. We want to eliminate prospective UR in that time frame. You know, UR
It becomes an automatic thing.
In regular UR, it's up to, you know, the claims administrator has 5 working days to make a decision. In some cases, people need medication right away, and it should not be a problem.
Right.
You know, in many cases, there should never be disputes over medicine.
So what is the obligation of a carrier or a TPA to use a drug formulary?
Well, they're required to use it. It's, you know, it applies to all drugs dispensed after January 1st of 2018, you know, to medication that people take home and take. There is a requirement that they use that. You know, there are other settings where medications are given to injured workers in a hospital or outpatient or inpatient facility, what have you, and we have other rules that apply to that. You know, our formulary, as I say, is based on the treatment guidelines. It's the medications were recommended in the treatment guidelines, and we have our drug list. Exempt drugs, as I say, no prospective review. We have non-exempt drugs and unlisted drugs. So if a drug is not on our drug list, that would prospective review is required. It would need to go through that.
Okay.
And then we have some medications indicated as a special fill or a perioperative fill. You know, for example, an opioid that's needed right away, that can be dispensed without prospective review. They could get up to 4 days before they would have to go through prospective review to get more. It's worked really well for us so far. We have a pharmacy and therapeutics committee that meets quarterly. I think their next meeting is going to be on November 20th, because what we want to do is start refining the formulary. You know, that we can pick out, we could have medicine identifiers or specific medications, specific doses that we can determine to be exempt or non-exempt. Again, we want to make sure the medication gets to injured workers quickly, but also we want to make sure that you know, we're containing, we're not having the Wild West. You know, it used to be that medication disputes made up almost half of our IMR cases. It's down to about 37% now and falling, so I think this is having an effect.
I see. Yeah, it's nice to get streamlined at all.
Yeah, and the WCRB found in August that it is having a positive effect. You know, our exempt drugs, use of exempt drugs have increased by 41%. Opioids, compounded drugs, physician dispensed drugs, you know, those used to be problems in our system. You know, they've dropped significantly because
That's
all of those.
Also due to putting all the bad doctors in jail.
Oh, that certainly helps, doesn't it?
So they do all those compounding creams and stuff just to get around the schedule.
No, it's kind of crazy
awful.
when you saw something that was essentially, you know, cayenne pepper and cold cream going off for about $450 a tube.
Yeah.
You know, that was just not right.
And then they litigated all the way to trial if we didn't pay them.
Right.
Which cost us too much. So
Yeah. Again, it's just, you know, it's just that friction in the system, and this has helped tremendously. And then of course, you know, we're seeing our pharmaceutical costs drop, which is great. There's lots of factors that go into that, but I think it is having an effect. You know, I'll turn to fee schedules now. We are working on updating our med legal fee schedule. You know, we've had a lot of problems.
Is a statutory mandate?
It's not a statutory mandate, but we had our regulations in place regarding our med legal fee schedule for a long time. I think the current version's been there since 2006.
It's a lot of pressure. We're losing med legal doctors, right?
There are declining numbers,
yeah.
and the doctors that we have been around for a long time. Yeah. We need to replenish the doctors that we have in our system. We need to bring more in. So you know, just in workers' comp in general. You know, you talk to physicians and they just say it's too complicated. I don't get paid enough. You know, there's too many administrative burdens. You know, I think we have to, you know, one, get that notion aside, and we can get that notion aside by making our system more efficient and more predictable, and try to increase all you know, the burdens that we put on our physicians. You know, it's a lot of work they do. They need to be reasonably compensated, and I think we want to move in that direction. You know, the med legal fee schedule that we had in place. You know, complexity factors, modifiers, you know, there were parts of it that, you know, were misconstrued. And I think what we need to do is get something that's, as I say, is more predictable for people and provides fair compensation. And so we put out a proposal in couple of months ago for a new fee schedule based on a flat rate, and you can see the numbers there: $1,650 for basically an exam, follow-up $1,100 in supplementals. We eliminated the complexity factors. We allowed additional payment for medical records. I think based on the number of pages reviewed. So I think about 400 pages were included in the flat rate, and then we were paying $2 an hour for every page above that. We increased the hourly fee for med legal testimony when we had modifiers for psychiatrists and psychologists, and then also a modifier for evaluations performed in underserved areas. So that's what we were putting out there. It's a proposal, and so we're still working on that. I think we're having a stakeholder meeting tomorrow to talk about this. What the fee schedule is missing, where it could be improved. And then parts of it that might need to be changed, so I'm really kind of looking forward to that. I'm looking forward to sort of getting something in place, something that can be automatically increased, every couple of years, so to put the noise aside on this. It's been something of a problem. Electronic reporting. As I had mentioned before, we were always a little behind in technology, and I think that's really an area that we have to move forward in. And we were given a mandate to have a doctor's first report being electronically submitted straight to us.
Right.
Right now I don't see doctor's first reports. That's something that gets put in the box. I never see, we never see, we don't use. And that's unfortunate because there's really a lot of great data in that report. And so by having doctors sending that report straight to us, it's going to be interesting to see, especially, how many claims are actually out there. How many times does a doctor, see an injured worker, but claims never reported to us? This will be quite valuable. We've tested this system. We're going to be using, I guess, a group of doctors to actually do some testing with this. For larger medical groups, it'll be electronic data interchange reporting to us. And that's going to go into place. We want to have that effective next year for everybody to use. UR data, again, I mentioned before about that coming to us. We're working with the department's IT unit to get a system that will get us UR data, because that's always sort of been the been a big mystery. Well, what does UR deny and what does it approve?
UR is expensive.
It can be. It can be.
It costs more than the medical treatment sometimes.
And sometimes it does. And sometimes you just wonder, well, why? How come more treatment just isn't passed through? Yeah. SB 1160 had that 30-day fast track provision. Everything within the first 30 days of treatment.
Did that help?
I think it has helped. Actually, I think a lot of people were really doing that. We looked at IMR data about those disputes that occurred within the first 30 days, and it's practically insignificant. So I think people should be getting that treatment that they need within the first 30 days. And I think if a lot of claims administrators realize, and most of them do, that if you give that treatment up front, you're going to have a better outcome at the end. If you're going to start nitpicking UR right away, then you're going to have a claim that's just going to go on and on and on. But this will help us see what exactly is going on with UR data. And then of course we want to start moving to more electronic reporting in our system, whether that's physician reports, requests for authorization. We'd like to have those submitted electronically to claims administrators. We think that could cut down on a lot of time that it's taking. And then that document repository, which I keep hearing about, and a lot of people really like the idea, is to have an online repository for documents so that everybody knows what documents are there. Whether it's a UR doctor, an IMR doctor, there'd be like a central place to go to see every document that's being used in a claim. I know there's lots of privacy issues with that we'll have to deal with, and whether we do it.
I'm not really clear on what that means. I mean,
that you would go
different than EAMS.
Well,
instead of case by case, it's doctor by doctor. You could
claim by claim. So it's not just adjudicated cases. You'd go online. You'd have to make sure you'd authenticate yourself, and then you'd have access to all the documents that are all the medical records that are in the claim.
You mean the for not just you guys, for the whole
system?
Right. Oh,
right.
Wow.
Yeah.
Defendants, applicants, attorneys.
Mm-hmm. Yeah.
Every document.
Yeah. So everybody's on the same page with what records are out there.
Everything about a given doctor.
Mm-hmm.
Wow, there are privacy concerns about that.
Yeah, there is. No, it'll be interesting. We have heard, some people have come into my office and have shown me systems that do this.
Too,
yeah, absolutely.
Wow.
And that's why I'm hesitant to do it. For the amount of money I pay for space, for data, it's just, it's crazy.
Yeah, well, it's a dream.
It is. We can dream.
We can dream. Someday it will happen.
I would hope so. Utilization review. We are updating our regulations in that regard, and the big part about that we're dealing now is the treating physician form, the progress report, PR2, which is a one-page form that's been in place for a while. We do want to beef that up. We want a better treating physician reporting form, something that's easy to use and something that will actually, transmit data, which will move a claim along. And we're working on this with physicians to make sure that we're getting the right amount. I think it's a fine line between too much information and not enough. But we want to incorporate the request for authorization into this form. We'd have better data regarding work status, evaluation and management section, and have this be an online form, something that can be submitted electronically, and also we'd have a hard copy with this. And so this is something we're still working on. It's in progress, but one thing we'll have to realize that if we ask doctors to fill out a better form, they're going to have to get paid more for the form, because I think our current PR2 pays about $12 and change. And I think this is going to have to be.
Why don't you make it so that the RFA could be on a PR2?
And that's where this is heading.
Can you make it so that your PR2 has a section in it, so that you fill out it becomes an RFA?
Well, we'd have to go in and essentially adjust the PR2, and I think that ship has sailed. I really don't want to do that. I think we just need a better form.
Because that would just be one form, instead of two.
Yeah. Well, this will be one form, and I'm looking forward to it, actually. I'll turn to IMR. Our IMR numbers, I'll show you these charts, but really nothing has really changed significantly.
Which is too bad.
Over the years. I agree.
I know that IMR is, they never anticipated, the authors of SB 863 never anticipated that there would be this much IMR.
I was actually quite surprised. When we first were drafting all of these regulations, we had always thought that IBR would have more applications than IMR, always. And that so is not the case. We thought we probably might see about 4,000 a month, but that's not the case. It's been about 20,000 per month. It's crazy. We want to see these numbers come down, and we'd hope that by having physicians adopt our medical treatment utilization schedule, use the guidelines, there'd be less disputes and there'd be less IMR.
If I'm an applicant's attorney,
sorry?
If I'm an applicant's attorney and I don't appeal UR, I'm afraid of malpractice.
That's what I understand.
So
that's something we really have to look at in our system.
I would do it every time.
Is what we need to do about IMR applications. How do we make sure that if there's a UR denial, that the parties actually communicate to determine what's the best treatment for this injured worker without having to go through this process. The numbers are slightly coming down this year. I think it's like, 8% or something. Which is okay, but really, we really need to take a hard look at this and see what we can do about our IMR system. What changes do we need to make? Do we need to have more doctor involvement in the system?
Applicants' attorneys live in a world of clients screaming about not getting medical care.
I have no comment about that.
Okay, that's what they live. All they can do is say I'm appealing to IMR.
Well, that's the process. That's the process we have in place. Yeah. They need to do what they feel is entirely appropriate. But again, it's kind of amazing the numbers that we've had. Almost 250,000 of them each year. The eligible ones. Once you take out the ineligible ones, it's
I don't see any end in sight. I'm going to go start an IMR company.
Well, we have one, and I think they do a good job. Maximus Federal Services, given the volumes that we have, and this is what we've seen this year. Again, the numbers are pretty rock steady, and they have been for the past few years. We're seeing, a little over, about 20,000 applications per month. When you wean out the ineligible ones, about 15. The ineligible ones have been dropping. I think I'm really happy about that. We had about 30,000 a few years ago. Now it's cut in half. This is when someone doesn't sign an application, doesn't include a copy of a UR decision. We give them a chance to fix it, and they usually do. If there is a treatment dispute, it should be decided. It shouldn't just get thrown out for procedural reasons. And these are the decisions issued. Not tremendous amount of change. We have seen a little drop this year, so I'm happy about that. But that's quite a bit. We do look at these decisions. If people have problems with them, we encourage them to contact us and let us know when they see problems with IMR decisions. And if we see mistakes are made, we do try to correct them as best we can. I think this is this is important because it kind of shows you how fast the process works. You know, I've had a lot of people say, well, yeah, I can go through IMR, but that takes forever. IMR takes forever. Well, it doesn't really. You know, Maximus issues their decisions far below the statutory requirement. You know, they're supposed to submit a final decision within 30 days after receiving the medical records on a case. Now, right now, they're doing it in about 7 days.
That's fast. It was an issue at first.
It was.
But it's not anymore.
Right. It was an issue at first because, you know, again, we didn't anticipate the great number of IMR applications that would come in. So there was a big backlog, huge backlog back in 2014, 2015, but they dealt with that. So now it's running fairly steady.
That's good.
In terms of case decisions, you know, basically you can look at this chart. We see 90% upholds of UR decisions and 10% overturns, and that has not changed since day one of the program. I'm really kind of surprised about that.
Wow.
I just thought the numbers would be different. That, you know, that at least we'd see probably about 40% overturns, but no, it's about 90% upholds, and and despite, you know, the type of request, that's pretty clear. Even if you look at it by geographic region, you know, you'll see approximately a 90% uphold of all IMR, of all UR decisions. In terms of treatment request outcomes, and this is this year, again, the numbers are about the same.
Okay, that's good.
Yeah.
What it should be.
And in terms of the different types of treatments, again, it's all fairly steady. Behavioral and mental health, I think, has a larger overturn rate, but you know, again, across the board, pretty much the same. Physician reviewers, these are the type of IMR reviewers that are used, and the percentages. We use occupational medicine about a quarter of the time. 60%. I see you see category of name value. That's, you know, 100 minus 37.4. I think that's about 62 something. So 62% of our IMR reviewers are licensed in the state of California. That's been going up, and I'd really like to see every IMR reviewer have a California license. You know, that's the goal there. I'll turn to independent bill review. You know, we don't get many of these.
Doesn't surprise me with like second review and everything. The process is so hardcore. I don't even see how you get to IBR without being Herculean in your efforts.
You really have to be quite diligent and persistent. You know, I think second bill review works fairly well. And I would hope that most of the disputes are resolved there. You know, we get about, you know, 2,000 IBR applications per year. You know, that's 5 minutes in the IMR. And that number is even coming down this year. So I would hope that the system is being used more. But if we're getting our bills, our billing disputes resolved earlier, that's great too. And these are our filings for this year. Again, you know, we're not talking big numbers here.
That's nothing. Physician
services make up most of the requests. But in terms of overturns, you know, doctors who file get money. I think it's, you know, it's about 70% of the valid IBR applications that are filed. You know, the physician is awarded money, and we've given about $1 million back to them this year.
Well, lesson learned for the defense.
Yeah. So
just knock it off.
Well, they have to really take a hard look at it. I mean, I've seen certain instances of billing objections that just make me scratch my head. You know, an interpreter at the board submits a bill and gets turned down because they're not in the MPN. You know, that's ludicrous. I'm having an audit unit actually take a more of a hard look at some of these billing objections.
You hear that out there, folks?
We have search tools on our website. You can look at all of our IMR decisions, actually, and I think we're going to be hitting the 1 million mark if we haven't done that already. That's really staggering to me, 1 million IMR decisions.
Wow.
I'll talk about EAMS briefly.
No, this is a big one.
You
told me that you guys are thinking about replacing EAMS, it just about fell out of my chair.
It's about time too. You know, that system has been in place for a long time, and to me, it was kind of dead on arrival on the first day it was used. Borrowed software, you know, different programs, FileNet for documents. It's very difficult to search. It's very difficult to use. And so it really wasn't that hard of a decision when we sat down and saw the last, you know, bill for the last upgrade to EAMS. You know, it's like, why am I paying so much for this? You know, to me, it's.
Well, when EAMS first came out, man, it was not good. I mean, people were griping all over the place. We say sarcastically, I thank God every day for EAMS, you know, it was just crazy. But it did function. And I have to tell you, over the last few years, I don't hear gripes about EAMS that much.
It's hard to use. I think people have just gotten used to it.
Oh.
You know, like you get used to that crazy uncle that comes by every so often. But I think we can do better, and I see that we can do better. You know, people have some people have come into our office and shown me case management systems that are incredibly impressive, and I think our technology out there has gotten to the point where we can do a heck of a lot better.
Well, EAMS was custom written, right?
Well,
okay.
Well, I think they took a program that Ireland was using, if I recall,
Ireland?
and customized it for us, and then brought in a couple side systems. You know, it's somewhat something of a patchwork system, and it's incredibly expensive to upgrade and operate.
Well, you can't be talking about replacing the whole thing. There's all that data in there. You got to be talking about upgrading. No, you're talking about replacing.
Yeah. Well,
how are you going to transfer all that data?
We will find that out. We're in the process. You know, our IT unit's working with the Department of Technology. They have a very systematic, comprehensive approach to doing these types of projects, and so we're moving along with that. And at some point, you know, we're getting our requirements for what we want in a system. We're doing that internally now. We're going to be reaching out to the public to hear what they want in a system. We want to, you know, use online forms. We want to have required online filings. We want to make it easier for our staff. We don't want to have to scan things in our district offices. We want better search tools. We want our judges to access our cases easier. So there's lots of moving parts here, and this is not something that we can snap our finger at and make happen. This is going to take a little bit of time, but that's our goal is just to replace this
well,
thing.
You are a man with a dream, because that just seems overwhelming to me. Maybe because I have my own software system here in my little law firm, and to think about that vast of a change. But on the other hand, you know, I mean, there's technologies for transfer of data too. And it's also scary, man, because what happens if you blow it and turn it on and it doesn't work?
Well, as I say, you know, I don't have a time limit for my job. I can I'll walk out the door.
They can fire you at any time.
Yeah,
anyway.
there we go.
Right. What do you really got to lose?
No, but I think this is really something we just have to as a system move forward.
Okay. Well, what's your timeline?
It's probably going to take, I think, about 3 to 5 years
to do the switch.
I think so, and I think there are a lot of people out there who are ready to help us and make it work.
Okay.
Yeah.
Well, it looks like we're getting to the end of our time. We have just a couple of minutes. There was a couple of questions we got. I'll ask them, at least one. What is the status of the interpreter fee schedule and home health care fee schedule?
The interpreter fee schedule, that has been problematic for me. You know, if it's simply just putting money on the service that's provided, you know, we could do that. We have a draft proposal where we're going to be using the fees paid by federal courts to interpreters, which I think is fairly reasonable. But there's more to it involved. You know, we first dealt with who selects an interpreter. Who selects an interpreter for a medical appointment? What happens if the interpreter doesn't show up? What happens if the interpreter is not certified? Well, who should the interpreter be certified with? Is there a time minimum involved for an interpreter? You know, travel time, how long do they have to be there? There's an incredible number of issues that go along with that. And when we put out our draft regulations, we got a tremendous number of comments on all of these different issues, and we have been working to try to resolve all the problems with that.
So
Frank,
when do you think you're going to get to it?
Well, I have a draft, and we're going through it right now. I'm probably going to put it up on our website forum. I'd like to do that probably within a month, and then we'll see where we go from there.
Sounds reasonable. What about the home health care?
That's something that has been lounging around for a long time. It was a matter of just trying to find a standard in which to fix fees. I think there was the IHHS. I'm trying to remember what.
No, they're one of my clients.
Oh, yeah. So we were trying to work their fees in, but I think we were given the authority to use the federal workers' compensation. You know, the the federal level agency,
yeah,
because they had some fees, and we probably will turn to
try
that.
going to trial on that issue.
Yeah. No, it's difficult. They made statutory changes a few years ago, which I think reduced the level of friction regarding that. But
so I'll keep your feet to the fire. When do you think you're going to get to that one?
I would like to get to that one by the end of the year.
Okay. I have another. I think we have time for one more. What about the recent regulation that changed for paramedics allowing psych to be easier to claim?
I'm going to have to claim ignorance on that.
Yeah, me
one.
too. I don't know what that is. Yeah. Based upon the new guidelines being proposed for MedLegal, how much would a psychiatric QME cost?
I think if I recall the numbers, given the average number of documents, about $7,200.
That's a lot.
Well, it's a lot of work.
So many documents. That's the thing. Sometimes it's boxes and boxes.
Well, and I think that's kind of the big problem, is really the number of medical records that are provided, to resolve a medical legal dispute. Yeah. How much is necessary? And that was, I think, one of the big things we struggled with. How many pages do you include in the flat fee? And then, of course, what do you charge for every page afterwards? Now, we had $2 per page.
There's services in India that will use artificial intelligence to review records.
I have heard quite a few stories. I've heard quite a few stories about that. Yeah. And I find that entirely fascinating. But again, how much money should you pay for every page? About $400. Do we incentivize people to read slower?
I think at the end of the day, we're just trying to keep ourselves as organized as possible while the computers completely take over our lives.
That's going to happen soon enough. I wish there was a computer that could be a parent to a 12-year-old girl, because I certainly am not doing a good job in that regard.
I doubt that's true. All right. Well, we're out of time. Man, it has been so enlightening for me to talk to you. And I hope for everyone else out there too. I'm really greatly appreciative to come in and just tell us, tell us all this stuff about what you're doing and who you are and the function, and it's just really enlightening.
Well, thank you for giving me the opportunity. I really appreciate it. And people, if they have any questions, they can certainly, send them to somebody other than me.
Well, it's like they are, according to what I've got on the board here. When I can't answer them, I'm going to email them.
That's fine.
All right, we'll sign off. Thanks again, sir.
Thank you.
Bye.